Well, Mr. Speaker, my first point on this is here we are dealing with yet another Conservative omnibus budget implementation act, and in a very, very significant portion of this act are changes to public service labor relations. And you have to ask yourself, what the heck does that have to do with a budget bill, and why would that be dealt with in our committee, a labor relations bill? So it's once again problematic that so much is crammed into this one bill with very diverse content. Later on we'll be dealing with appointments to the Supreme Court. We just dealt with a section on immigration, and the ridiculousness of this is very frustrating. These changes to the Public Service Labor Relations Act are very troubling, and I have to ask the government if they really want to prompt a deterioration of labor relations in the public sector, because that's what's being provoked with these changes. And I don't know, maybe the government thinks it's good politics to poke their finger in the eye of hard-working public sector workers, people who are paid by our tax dollars but who work very hard and do an excellent job on behalf of Canadians. The government belt-tightening has already seen the layoff of more than 20,000 public sector workers. Many are working very hard. We've seen a lot of complaints, whether it's from veterans or from seniors, people trying to get access to EI, people concerned about cuts to search and rescue. Services that have been cut and in some parts of the country are simply impossible for Canadians to get access to. And these are public services. This is the work of the public sector, and that's whose jobs we are talking about. Now, this first change is about the definition to essential services, because what the government's proposing with Bill C-4 is to give the minister sweeping powers to designate groups of workers as essential. Now, that may sound like a good thing. We can all imagine essential workers. If your house is on fire, you don't want the firefighter to say, I can't come right now because we have a labor issue that I'm dealing with. So there are some situations where it makes sense for there to be a designation of an essential service. But there's no definition provided here, a list of criteria that objectively one can point to say what would make that what would make some essential and some not. And there is real concern that these powers will be used by the minister to designate groups of workers as essential strictly for the purpose of undermining the ability of that bargaining unit to bargain collectively and defend their rights. The definition that does appear of essential services appears to run contrary to conventions of the ILO, International Labour Organization, and this amendment would change the definition of essential service to reflect the definition from the ILO. The ILO provides an internationally recognized definition, and that's what is provided in this amendment. We believe that this important status of essential workers should actually be based on actual criteria rather than a very loose definition that leaves the minister the power to designate people at will and really strip them of their full collective bargaining rights. We think this is fundamentally undemocratic. It runs contrary to internationally agreed upon conventions and is a very dangerous, slippery path that this government goes down. It would give the minister incredible arbitrary powers. And as one of the witnesses said to us, it's like giving Coca-Cola, which is one of two parties in collective bargaining, in labor relations, giving Coca-Cola the power to say that whole groups of employees in their workplace are designated essential and unable to exercise their full collective bargaining rights, their full labor rights, because it suits the employer and it's convenient and perhaps advantageous for the employer. That is the power that the minister is giving himself with these changes. So we think that's fundamentally wrong. And we had several labor experts testify here telling us why that is wrong and why it's an affront to the practice of labor relations and to all of our experience in Canada and international experience. And on this particular clause, we're proposing an alternative, which is an agreed-upon international definition, which will give some clarity and some balance to the collective bargaining relationship, rather than really tipping the scales to the side of the employer, which in this case is the government. Thank you, Mr. Chair. I neglected, before I got into the detail of the amendments that we're proposing, I had just wanted to make another point, which is that given that this is a new model that's being proposed by the government, I just want to say our amendments are based on a concern that we have that the government is rushing into these changes without adequate consultation and without the necessary checks and balances. And we've seen really the mess the government's made with the temporary foreign workers program, where there were concerns raised by employers, by communities, by workers who were concerned about their rights not being respected, about taking Canadian jobs. There were concerns expressed, and then the government's had to amend what they brought into place. So our concern is based on the experience that when you rush into a new system and you don't have proper checks and balances, that's where you get into difficulties. And so because we don't really have the information from the government about why they're making these changes, based on what recommendation, or and we don't see the transparency of monitoring the changes once they are made, we're concerned what that's going to mean, and that's why we've proposed these amendments.
Okay. Thank you. Thank you very much for that. And we have also NDP 17.1, NDP 18, NDP 18.1. To address these, Ms. Nash, please.
Thank you, Mr. Chair. And as my colleagues have said, this expression of interest system comes through the minister's new power to issue ministerial instructions that will bring this new system into effect, but without being able to access those instructions and provide a public opportunity to respond. We have no way of knowing if this is providing an adequate review of the system or not. So we have amendments that would provide a proper and public review of the system once the instructions are public. Specifically, it would require the minister to publish any proposed instructions for consultation for a period of 60 days and to consider the feedback before making them final. It adds a requirement to review the application of these changes every 3 years after they come into force, and each year thereafter by a House of Commons committee. It's just a check and balance so we can measure and evaluate the impact of this new system, the expression of interest system. And as above, it details the broader role of the committee in that regard. So that's the essence of the three amendments that the NDP is proposing.
Okay, thank you. Further debate?
This amendment would eliminate the ability of the minister to throw out a refusal on the grounds of it being in bad faith or being trivial. Again, we don't believe that the minister has the ability to determine that, and that the concentration of power in the hands of the minister, we think, could be detrimental to the health and safety of people working in federal jurisdiction workplaces across this country. So we're proposing that this ability be eliminated.
Okay, thank you. We have NDP 10. Ms. Nash.
Yeah, this is about making sure that, given that the minister is concentrating all the power in his or her office, that that they're getting a full picture of what's going on in a workplace. So right now, what C4 would do is, if there's a health and safety committee, and the committee is not unanimous on something, on a decision or on points of view on something, only the majority, or the decision or the majority viewpoint would be reported to the minister. But there may be a diversity of opinion, there may be a minority opinion, and we believe that the minister ought to be able to get all of the information. So if something is, if a decision is not unanimous, we think that all the results should be passed on to the minister. So that's what this amendment, NDP 10, will do.
Okay, further discussion. Ms. Nash, to address your amendments in this clause, please.
Sure. And I just want to say, first of all, we support the motion, the amendments put forward by Ms. May, as well as putting forward our own amendments that I'll describe in just a moment. I want to start off by saying that I think that the changes that the Conservative government is making about workplace health and safety are the most serious and dangerous changes in this bill, and I'm very, very strongly opposed to them, as are many of the witnesses that we heard testify before committees. It's I have to say, when I first started getting involved in my union as a young person, it was as a health and safety representative in the federal jurisdiction, and so I, on a personal level, really valued the health and safety legislation, and I saw it progressively get stronger over the years. And these changes would in fact take the legislation back in time many, many years, and ultimately, I think, make the workplace much more dangerous and less desirable for Canadian workers. Fundamentally, every worker deserves a workplace that is safe and healthy, that's free from danger, free from health hazards, and the obligation is on the employer to provide that safe and healthy workplace. That's their legal requirement. But working people also have rights: the right to refuse unsafe work, the right to know what they're working with, the right to participate in their health and safety. But how you define the right to refuse work, for example, is changing dramatically. It is becoming narrowed by this legislation, and what that means is there are conditions, workplace conditions, that previously would have meant that a worker can decide that it is dangerous for them, and they could have had the right to say, I don't want to put myself in that situation. And with these changes, they would be obliged to continue to work. Now, I don't think we have an absolute epidemic of work refusals in this country, It's a pretty serious step for someone to refuse to continue to work. But when someone does refuse, it is the right that they ought to have in order to protect their integrity of their own health. And it is really rolling back the clock to narrow this definition. And let's make no mistake that it will increase the risk that workers are subjected to. It'll increase the injuries. It'll increase, in fact, the compensation claims and the lost time, and ultimately be very dangerous for workers. But it's also it doesn't make good economic sense on that basic level. So speaking to our amendment on narrowing the definition of danger, we believe that providing an alternative definition that's more substantive in scope is important. Again, we think when it comes to a person's individual health and safety, that none of us wants to be put in the position where the employer is saying you must work, even though you truly believe that it is going to be a serious health risk or a serious risk to your safety. The other amendment is about the change that the government is making, which is to strip health and safety officers of their powers and concentrate nearly all of these powers in the hands of the minister. The minister has a myriad of other things that they are responsible for. They cannot have the expertise of a health and safety officer who is trained, who does this for a living, who is an expert and has a track record when it comes to health and safety. It really makes no sense. And again, as I said in a previous on a previous clause, it lacks transparency and accountability, and ultimately will undermine the ability of people to get their rights enforced in the workplace. So what we're doing with our amendment is to undo the elimination of health and safety officers while requiring that they be government employees and not be outsourced or have that power concentrated in the hands of the minister. And I just want to say that one of the changes in the rules, which we find is remarkable, is that under the changes in C-4, there would no longer need to be a physical inspection of a work site, an actual workplace, that a phone call will suffice. So you can just imagine this, the employer sitting in an office, and someone from the minister's office or someone they've delegated phones up and said, basically, is this okay? Have you got that done? Did you do this? Are you going to do this? Sure, everything's fine.
Good to go.
Good to go. And the fact that they would not have to go there and lay their eyes right on that situation, inspect it for themselves, is frankly shocking, and it's unbelievable. I just can't imagine that we would require, allow that situation through our laws. This is Canada, and people have a fundamental right to a safe and healthy workplace. So we're strongly opposed to the changes that are being made through this bill. We believe that our amendments and Ms. May's amendments would help correct some of these changes. And again, I would urge my colleagues across the way to put yourself in the situation of someone who's trying to get a basic right enforced, and that employer sitting in the office telling an inspector over the phone, we're good to go, no problem here. I think it's hopefully you will support our amendments.
Thank you, Ms. Nash. I have